The next session is by our most respected Naavi sir from Bangalore. He's going to be dealing this topic. Naavi sir is popularly known as Vijayashankar sir is popularly known as Naavi and is renowned information assurance consultant based from Bangalore, India. And though not a lawyer, he's a pioneer in cyber law, authorizing India's first book on the subject, Cyber Laws for Every Netizen in India, and several other notable works. He introduced the Cylacom concept to promote voluntary cyber law compliance and develop training and certification systems for it. And his profile runs long, and his extensive background includes 40 years in the various business roles. Thank you, sir. Now it's over to you.
Thank you. So friends, of course, we are actually talking of a very difficult subject. Okay. Section 65B, of course, we had a lot of time to actually understand. In fact, the first Section 65B certificate was produced in the Suhas Katti case in the AMM court. Balu was there, Napinai was the defense advocate. I was the person who submitted a CEAC certificate, a certificate. Okay. From that time onwards, we have been discussing how a cyber evidence certificate has to be provided. Now, by the time when we started understanding something about it, who has to submit, what has to be submitted, now this new act has come, so we will have to relearn the whole thing. With that, some changes also they have made, which are not easy, it is substantial. The changes. So it has also introduced some new doubts. Okay, I may not say that I have answer to everything as of today, because we need to discuss, and anyway Shastri has already spoken eloquently on the intrinsic value of evidence, whether it is worth or not. Okay, so but you have an act, you have to work around that. So there is no way of saying that, okay, we don't like that, it is different. But even if you don't like it, we have to find a meaning out of it. So that's why I was telling the judges that perhaps they will have to read meaning in an appropriate manner, or only Supreme Court can do that, but still we have to make an attempt. Okay, so let me try to give some thoughts on the issues for us to understand. Now we will first go to section 63, the first part of it. The most important thing we have to look at it, this says notwithstanding anything contained in the Adhiniyam. But of course this is part of the Adhiniyam. So you cannot say that it has got nothing to do with the Adhiniyam. Actually it is notwithstanding anything contained in respect of the oral evidence, or say evidence can be of three types, no, oral, documentary and electronic form. That is what the earlier section says. There are three forms of admissions. One form is oral, one form is documentary, another is electronic form. So in the earlier act it was very clear that there are these three forms. The earlier old act, 1872 act, had discussed about how to present oral evidence, how to present documentary evidence, and then this electronic form had come. So this notwithstanding applied to the oral evidence and the documentary evidence, and this section 65B applied to this new form of evidence called the electronic form. Therefore it was very clear that notwithstanding what is there in the earlier section 60 or 61, 62 and other things, ultimately it came to section 65. Now there was actually this notwithstanding itself is creating a kind of doubt. I will come to that. Now the first thing you have to observe in this act is section 63 first subsection, which talks about the computer output. The first thing, if you say any information contained in an electronic record, okay, the electronic record can be printed on paper, it can be on semiconductor, it can be on something, okay, so that's fine. Which is referred to hereafter as computer output. That is very important for me, because this means that section 63 subsections 2, 3, 4, 5, all of them refer to computer outputs. there is a original electronic record somewhere, you are creating a computer output for the purpose of evidence. Okay. Now, this whole section is how to enable production of an electronic document which is lying somewhere into the court. For example, if you recall what was there in Suhas Katti case, in Suhas Katti case, the object of crime was a Yahoo e-group message. It was available in groups.yahoo.com, lying in some USA and other things. We could not go and seize Yahoo server or something there. It was not necessary also. You must understand, in 2004, the AMM appreciated that. What we did here was, sitting in Chennai, we logged into Yahoo group, something came on my computer. I certified that this is what came on my computer when I opened a browser, printed groups.yahoo.com, etc., etc. That is the process by which I accessed a particular document which got displayed on my computer. I took a printout of that and said that after following this procedure, which is having a computer connected to internet, opening a browser, and then typing in the URL particular this thing, we got a particular page. And I have given a printout of that page. That's all section 65B certificate required. Okay. Now, what is contained in that is for the judge to decide. Okay. The section 65B person is not going to say that it is an obscene information or something like that. Okay. Interpretation of the content and its value in terms of evidence is for the IO to suggest to the court and the court to decide. Because in that particular case, there were certain words were used, were considered as section 67 offense at that point of time, obscenity. Okay. Now, you could have argued whether it is obscene or not. That is a different argument. As a section 65B certifier, my role was just to drag that electronic document, which was not accessible because it was lying in some server, to the attention of the court, for which there is a certain procedure which I have used. I have explained that. At the end of it, what comes in my computer is the computer output. See, this act says that, the section 63.1 says that we are trying to develop something called a computer output, which will be the thing which will be the subject matter of discussion for evidence subsequently. Okay. So, that is what is also stated in the section 63 subsection 1. This is very important because in the subsequent sections we will be talking about whose computer you are talking of. That is, the computer should be working in good condition. These are all things. Who is the owner of the computer? Now, all those things, are they related to this Yahoo server? Then nobody can submit a server, any evidence. Suppose you say Facebook. You cannot bring a Facebook owner and say my server was working properly or something like that. So what this section actually enables, I'm talking of section 65B continued here, was that you don't have to bring the original server. You don't even have to bring the original hard disk. You have to only create a computer output which is a faithful reproduction of what is the evidence, and section 65B evidence certificate giver is only trying to say that this is a matter of fact certificate. Like a photographer takes a photograph and gives that photograph, he doesn't know who is who here. I take a photograph and say on such and such a day I have taken this photograph, this is the evidence. You call him into the court, he will say this is the photograph I have taken. But he is not going to certify what is the speaker speaking, who is the person who is sitting here, whether he is a lawyer, whether he is a student. These are matters which the IO will have to explain and the court has to accept. So this photograph is the output which this person is producing. What we are seeing in this section 63 also is that just give that computer output. Let the other aspects of evidence, let it be brought in to explain the content of the particular information. Okay, we'll come back to this again after complete a few things, then we can have some questions also. So this is the first thing I want to point out in this particular section, that you are looking at a computer output. Okay, now second, without further proof of production of the original, it says. Okay, again in the earlier IT at 1872, there was some kind of a clarity. People like us were telling, in a computer document, never ask what is original, what is primary, what is secondary. Because in computers, there is no primary which can be produced on the court. Whatever you produce, it is a secondary. It will be a copy. In fact, Krishna Shastri was telling that original comes in the RAM and then only it goes to the storage, which means that from the storage, whatever you give is secondary copy only. The original copy cannot be produced because RAM you are not going to produce. In fact, if you are talking of RAM, there are of course software today to say that I have captured this from RAM. Okay, so forensic people may do it. If you look at Information Technology Act, Section 4, that says that this volatile information, that is information which cannot be available for further reference, is not recognized at all under the Act. I will show you that this thing. Okay, so this RAM information is, for example, is the first information. Now, and then it goes to the storage kind of a thing, which means that everything is secondary. It is very difficult for us to think anything is primary. This is my view. It was under 65B, it was fine. But now in this section 63 and the current this thing, they have tried to actually define primary. I will come to that, the problem which it creates. They say that there can be a primary electronic document, and of course the certified document is secondary. Fine, that we even earlier we knew. So primary document was never the object. Computer output was the secondary document. So here also we may have to look at that, and it is admissible in any proceedings without the original. Next one, okay. So this computer output is the first point we have to make a note. Then notwithstanding whether it refers to some specific sections or it has to be, it is not to the entire act, because we are interpreting section 63 under the Adhiniyam only, not outside the Adhiniyam. So you cannot say it is notwithstanding anything contained in the Adhiniyam. They should have actually said notwithstanding anything contained in section so and so, so and so, so and so of the Adhiniyam. If they had said, it would have been more clear. Now, without further proof of the original, I will again discuss that this point. Now, what is original, what is primary? This is another question which we may have to perhaps discuss. Is original same as primary? Okay, I don't know. Okay, what you say? Original is the primary. Okay. So, as for my mind also, it appears that original and primary are more or less the same. But this act, they try to define primary. So, without producing the original, you can produce something else, is of no consequence. Anyway, next please. Because under section 56 and 57, they talk about primary evidence. Now again, the word document has been very loosely used. Okay. Now at one point of time, they say electronic document is also, electronic record is also a document. Okay. See, the definition of electronic or digital, you have to go back to ITA 2000. Okay. How you can interpret under ITA 2000 is any expression in binary form is an electronic form. What do we mean by binary form? Express in zeros and ones. So there has to be a device which can read that zeros and ones and convert it into a human experience. Okay. So electronic form means anything which can be expressed in binary form. Okay, because there also they have gone around a checker. If you say what is electronic form, what is data, what is information, everything, if you combine, what comes out is that any binary expression is called electronic document. And A machine which can understand that binary information is called computer. So the essence of ITA 2000 is, it is a law of electronic documents. It is not a law of computers. In fact, when I define cyber crimes, I normally say cyber crime is a crime which is where electronic document is a tool of crime, or electronic document is a object of crime. See, what Vastu Shastri was telling about computer is the tool or computer is the target. This is what FBI also has defined. But while I was discussing ITA 2000, I felt that instead of that, we should say that where an electronic document is a tool of crime or a target of crime. See, where is the electronic document? It sits somewhere inside the computer. Now, computer is a device which holds the electronic document. Electronic document is not the computer. Okay. So when you talk of evidence, computer is not to me an evidence. What lies inside as an electronic document is the evidence. Now I will give you an example also. Now okay, we'll come back to this later. I have got one more this thing. You just go. No, I will come to that. You take go forward to 3 or 4 these things where there is a picture. Then we can come back. You stay here. Now, on the right side, you have got this CDs and hard disk. Okay. And now, the question is this the electronic document, right side? Most of the time we think it is electronic document. We say that we have produced the CD. Okay. And what is there on the left side? It is a binary form and a QR code. Now, is this an electronic document or is the holding device an electronic document? I've asked a question, a bullet and a gun. Bullet can reside inside the gun. Okay, which is the bullet? Bullet is different, gun is different. Likewise, suppose let's say your murder weapons are found in the scene of crime in a trunk, let us say, a almirah, cupboard. Okay, now you don't seize the cupboard and take it to the court. You take only whatever was contained, but in your major report you write that this was available in the almirah. Fine. So computer is like that. Computer holds the electronic documents, but what is important for evidence is not the computer. It is the evidence. Okay, which is one electronic document in the whole 500 GB of this thing. That is why when you say seize, we want to seize evidence, not the entire computer. Okay. Now, if we cannot do that, we do it. That's a different question. Okay. But in fact, when summons are issued or you issue the seizure notice, I think it should refer to the required electronic document. And it's like Hanuman going and bringing the whole, Sanjeevani, this thing. No, what is there on the right side, in my opinion, is not the electronic document. No, that's what I'm telling. There are certain things which have not been properly represented. Now, what is electronic document is zeros and ones. Okay, now, next, you'll come back to that. Two more these things. Another picture is there. Okay. Now you open it. Okay. Now, when you say the zeros and ones is the electronic document, is there any doubt on that? It is the electronic document. But can a human perceive that? Mudiyada. So, what is a fact under the act? Fact is something which is human perceivable. Okay. So, therefore, the zeros and ones stack is not humanly perceivable. But what happens? We actually put through some device. Okay. Computer, which is a software hardware device, and put this electronic document through the device, then you get to see something or hear something or whatever is that. Therefore, this, whatever we talk of as an electronic evidence, is actually the electronic document rendered through a computing device. Now, the device which you use actually has an influence on what is that the human is going to perceive. I've given here 3 different instances. Okay. Now, there is something, now you have got binary zeros and ones. Now I want to convert it into human understandable information. Okay. Now there is something called an ASCII converter. What is this ASCII converter? Binary to ASCII converter. So it will convert this binary zeros and ones into letters and words. Okay. Using a particular protocol. Now, like computer has got a software, there is a protocol for converting binary into this. Now that has been adopted by the whole system. Now it is not something which is a God-given this thing. Okay, computer world has adopted a protocol. Okay, now that protocol converts binaries, zeros and ones into letters. Now if I use an ASCII converter in this particular case and use it in English, I convert this into T-I-R-U-P-A-T-I. Now as a human I read it as Tirupati. Now for computer it is not Tirupati, it is this thing, okay. But the same thing, if I use a numeric converter, the same zeros and ones come out as a number. Now if I use instead of English a Chinese, I get something. Now the human perceivable impact of an electronic document is dependent on what software and hardware I use. Which means that if you like Shastri said, if you ask that in the class examination, why did you use an ASCII converter or did you use a numeric converter, the answers will be different. Two experts may come and say, one expert may say this 0 and 1 means Tirupati. So what is that information sheet or something you got? It represents a place. Maybe murder has got some connection with that. Another person will come and say, no, it has got a number. It may be a bank account number or something like that. So the evidences can have multiple meanings. No, same feed. No, I am saying the same feed. You are in India, Tirupati na generate, Tirupati photos just because the Chinese is not going to come. No, we are talking, no, you are deriving Tirupati from the binary document. From the binary document. See, at the time of, that is, okay, I understand. Now, what is that the criminal has done? We don't know. No, wait. I can even type this 6082. No, I can type 6. No, then that's why. No. Correct. That's why what I am saying is, what we call as electronic evidence is a combination of the zeros and ones, the computer or software used to convert that into a human readable format. No, that's why. That is why. Now, who has to decide whether I should use an ASCII converter or a numeric converter? But you don't have to do it. But if you don't use an image software, it will come as gibberish. The mobile itself is not an electronic document. What is inside is the electronic document. What is inside is a particular document. That document is stored under a particular format, say .doc or something like that. Now when you say .doc, you are already using a software to convert the zeros and ones. Instead of .doc, if you had used .jpeg, okay, then the same zeros and ones will come something different. Now I am only trying to say that there is a relationship between the binary document and the devices used to render a human experience, and this is the reason why no electronic evidence can be accepted without some human coming and standing there. if I convert this electronic document using a ASCII converter, this is a number I certify. This section 63 certificate wants to convert the machine readable binary into a certified human experience, and that human experience is given by that certifier whom the court looks at him as a witness or whatever is that. Then it becomes a oral evidence. See, you can always give a oral evidence. That's why, see, if you want to give a oral evidence, you can give a oral evidence. Okay. No, I understand that. See, there what is happening? No, wait. No, wait. Now, okay. Now, 1 minute. Now, that's fine. No, that's fine. Now, what I'm saying is electronic evidence is always dependent on the devices used to access it. Now, in your case, you have accepted this mobile. Now, that mobile, if it is, let's say, Apple instead of Android, how do you know it will render the same thing? No, I understand that. See, no, correct. The criminal jurisprudence which says beyond reasonable doubt is not correct, because agreed. See, even what we see is different. Say, I may have a color blindness. I will not see the colors which you will see. That is why I am saying that is the computer output, and that is what is being certified. That is what the section also says. No, I agree with that. Now, that is what the section also says. I am saying section also is saying that what is important is the computer output. Okay. Now, and now you are certifying the computer output. Now we will come to the next this thing. Now, where is the computer output developed? It is in the computer of the observer. Okay, the observer is going to be certifier. So the observer actually creates a computer output on his computer by using a process. That process may be going to internet, etc., different. Or he may go to a hard disk, a C drive, / so and so, for whatever is the folder. That is a process. In the mobile, he has to open the gallery. In the gallery, a particular this thing. Okay, that's also a process. So if I say that I took Vijayashankar's mobile, it will be closed. I opened it, maybe using the password or whatever is that. Then there was some icons. one of the icons was gallery. I clicked on the gallery, several things came, I searched, and item number 25, I clicked, and this picture came. Okay. Now, I am going to certify that. No, why it is required is, no, okay. Now, if I don't certify, you are this judge, you are assuming that these processes are the processes which you are going through. As a judge, you are becoming a party to the process by which the evidence was created. Do you want to be a party?
It was not created, sir. Please.
Output.
It was captured
No, wait.
by me in the mobile, sir. That is
No,
getting
say
reflected,
the
sir.
capturing itself. No, wait.
Sir, முன்னாடி ஹிந்துஸ்தான் போட்டோ பிரிண்ட் தரீங்க போங்க சார். ஃபர்ஸ்ட் என்ன பண்ணுவாங்க? போட்டோ எடுத்த உடனே அது
நெகட்டிவ் ஆயிடும்.
அதை வாஷ் பண்ணிட்டு நம்ம என்ன பண்ணுவோம்? நெகட்டிவ் பிரைமரி எவிடன்ஸ் ஆகும். பாசிட்டிவ் ஒரு செகண்ட் எடுத்தா மார்க்
சரி. ஓகே.
அதுக்கு பதிலா என்ன சிப் வந்துச்சு. அந்த சிப்ல அவங்க போட்டோ எடுத்து சிப்ல ரெக்கார்ட் ஆகுது. 0001 ரெக்கார்ட் ஆகுது.
ஆமா.
நீதிபதி முன்னாடி அதே வந்து போட்டு காட்டுது.
No, what is that which is showing? It is a graphic, let's say, reproducing software. See, there is zeros and ones, and then you have to have a software which converts zeros and ones into a graphic image.
Was it not the same software which converted that physical image into 001?
Not necessarily. It's one part of it. See, converting an image and into 001 is one part. Reproducing this back to image is another part. For example, you take a printout or something like that. No, I will tell you. You take a color photograph, but your screen is not color. You have got only black and white. Then what will it render? It will show it as black and white. So, the reproduction system is different from the other one. Even if one single software is doing, it is operating in two modes. Capturing mode, reproduction mode. Okay. Now, otherwise what will happen? You as a judge taking the responsibility for the system of reproducing it. That is, if you say electronic evidence is zeros and ones, it is not human readable. Therefore, I want it to be rendered on a screen, which our eyes can see. I want to adopt a process. Now, who has to decide what process? Now, in this system of section 63, 65B, what it says is, bring some human witness, let him take the responsibility. You as a judge say that under these conditions, Mr. X as a witness is certifying that this is the picture. I will take a view on that for judgment. Say, for example, this came up in the AMM court in the Trisha murder case. In the Trisha murder case, okay? Say, in that case, police had seized a CD. CD was already an exhibit in the court. So, the judge could have put it in his computer, viewed it, and taken a view. I have got to know this thing. But what he felt was, if I take a view on what is contained in this CD, I become a sort of a witness on my own. So, he asked an external expert, in this case, I was called in, to view that CD in the court internal chamber, and I was asked to take the printout and give a certificate that the content of the CD is what is reproduced here. Then as a judge, you are trying to see it as a document and then take a decision. Okay? Correct. See, IO will have to explain that. Again, my contribution there is only reproduction of that. Now, whether it is of Scene, whether it is of Trisha, whether it is of somebody else, that is what IO is arguing, and the judge is accepting or not. Okay, so this is the process which section 65B upheld to say that you look at a computer output and let somebody give a certificate on the computer output, and that will become part of a documentary evidence. That is, electronic form of evidence is a third kind of evidence, and this will be proved by this section 65B in the old this thing. And so the judge was given an option. If it is oral, you adopt this process. You call him on the witness box, ask him to say something, you hear it, and then you go ahead and do it. If it is a documentary form, let him produce the document. At that time, for paper document, there was a whole system of what is primary, what is secondary. When secondary documents in paper form could be given instead of the primary. This was all there in the old act. Oh.
ராமஜெயம் மர்டர் கேஸ் என்னன்னா ஒரு ஜுவல்லரி ஷாப்ல போவான், இதெல்லாம் சாத்தியிருக்கும், அப்படியே அந்த ஜுவல்லரை வந்து அப்படியே ஸ்ட்ராங்கிள் பண்ணி கொண்டுட்டு ஜுவல்லரி எடுத்துட்டு போவான். ஒரே ஒன்று என்னன்னா சிசிடிவி கேமரா மட்டும். ஓகே, போலீஸ் எந்த யாருமே நாங்க என்ன பண்ணினோம், அதை அப்படியே போட்டோம். அதை சிசி என்ன பண்ணாங்க, இவங்க அப்படியே சீஸ் பண்ணிட்டாங்க. சீஸ் பண்ணிட்டு கோர்ட்ல போய் அப்போலாம் அந்த ஹேஷ் வேல்யூ எதுவுமே தெரியாது, மார்க் ஐடியா கிடையாது சொல்லிட்டு போயிட்டு டைம் பேக் நம்ம என்ன பண்ணோம், உட்காந்து அப்படியே போட்டோம். Murder, first time I am seeing a murder happening. There is no murder used to be only to eyewitnesses and the witnesses. First time I saw how a man could really commit a murder. That's why compare பண்ணோம்.
No, I understand that, sir. So, no, say, I will give you one case where how I have done in a particular case. No, I will tell you how I did in a particular case in a CCTV footage. This was a case where there was a business environment, okay? There was a cash count. இருக்கணும் தான் சொல்கிறேன். Yeah. See, now I will give you another example. No, I will give you another example, sir. No. Okay. Made it. Okay. Now, are you going to yourself say that I saw it, therefore I will give an order?
I will recuse.
You will recuse because, but you can become a witness in the other court. Okay, so being a witness and being a judge of the incident are two different roles. So what I was talking of in this court, this thing is if you are able to view the CD, you come to your judgment, that is okay. You are a human being, you can read it and see it and come to a judgment. But to put it as part of the evidence, you are going into that witness kind of a hat, which is better avoided. So that is why this act says, have a computer output, let somebody certify that, then you view it. The CCTV footage, how I argued in created in a particular case is, this was like a business environment. There is a cash counter, there was somebody who slapped somebody else, something like that, okay? So there was a CCTV footage. So what I did was, I went to that place, saw where was the positions of the CCTV camera, and took some sample, these things, that what view is captured by this camera, what view is captured by this camera, and then said camera so and so captures the cash counter, okay? Then we went into the DVR. In the DVR, there are of course, hour by hour this thing, okay? So that is an electronic evidence. So we captured that, and then in my report, I said all these things. That is, a sample of this particular camera takes this, and then in the DVR there are different cameras, and the capturing is for our kind of a thing in different these things. Out of that, we went to that particular file which represented that particular day and particular hour, and that is a video. That video is the electronic evidence.
What is the exact difference between the electronic document or digital document?
There need not be any difference because but both are no, in documentary terms, whether they use the term electronic form, they don't even use electronic document in ITA 2000. That document can be in electronic form. Okay. What is electronic form? It is using the language of binary. Okay. Digital is also binary. Binary. See, digital and analog, you say the difference. Digital is capturing things on zeros and ones. Analog is on a continuous basis. For example, when you render, let's say, voice. Now, earlier things were all actually analog. So the wave is captured, that is going and reproduced. Now, this wave is going to be converted into a digital signal straight away, somewhere here in this thing. And further transmission happens only in digital form. So therefore, today, even a voice is a digital document. Video obviously is a digital document. In a video, when the computer screen is reproducing it, each pixel, it will give a particular value. Okay, that value will be an RGB value, red, green, blue or gray or something like that. So the computer will only record the grid, how many pixels are there. Each pixel, it will record some 0, 1, 4, that 8-bit value it will have. So the video also is an electronic document. So it is digitally captured. That is, when we said digital, we are actually talking of zeros and ones only. There is no difference in technical terms between digital and electronic. Okay, so if they have used it, they should have avoided it. That's all I can say. Okay, but every electronic document requires a human interference for the certification. That is why Section 63 talks of a computer output being produced and certified by a person who is called the expert. Now, this computer output is not produced in Yahoo server or it is not produced in Facebook server. Computer output is produced in this computer. Now, again, if you go back to Section 65B, this distinction of the owner giving a certificate was not there in Section 65B. So, I could take your computer, see what is there, and make a copy, and I can give a statement saying that this was available in somebody else's computer whose particulars, computer number, everything I was recording in my statement, but I was not asking you to put a signature in the same document. I was perhaps only making it as my confirmation. In the court, people could have asked, how did you get that mobile? I have to say the mobile owner only gave it to me. So in my certificates, I would say I was handed over a particular device by so and so who claims to be the owner of that. Okay, sometimes we look at the ownership in terms of a SIM card is in a different name, this is in a different name, then what should I do? I should ask him, please confirm that it is your mobile. In my report, I add that so and so has invited me to give a certificate and handed over his mobile, and this is what I observed. So my certificate did make a statement that there was a computer owned by so and so, which I actually used it. Now, but computer output was being created in my computer. Okay, so this question of whether the computer was running properly during the system and other things were all, and who was the owner? I was the owner of my laptop. If in my laptop I am observing, let us say, Facebook and taking a photocopy, I am the owner of the computer output producing computer. It is not the one where the original may be lying. Okay, even if you go to say Facebook or something, it is not lying in one computer. See, any web page is a combination of hundreds of mini files. These files, for example, picture file may come from California, word file will come from some other this thing, and it is all combined when you are in that particular page. You are aware of that? A web page is not a single document. It is not like a PDF document where everything is there. When you go to a web page, there will be at least 20, 30 files. Okay, one file will be in one server, another file will be in an entirely different server. In fact, if you are going from India, the advertisements will be relevant to India. If you are going from Australia, the advertisements will be different, because the web page is actually in a way linked to a program. So therefore, ultimately what is there on the server is immaterial. What was visible to a visitor from India in a similar circumstances when the crime happened or etc., that is what the certifier has to capture and say, when I did this, this is what I got. Again, this color and other things are still there. If I am, my color rendition in my computer may be different, in your computer may be different. I cannot give a certificate that a saree was of this particular color, a painting was this. It is very dangerous to give that because it is totally different. These are basically the problems of electronic documents, which section 65B had earlier captured. 63 tries to capture the same thing. That is why a certification is a mandatory requirement. Where we have created confusion now is this introduction of this. So that is why section 63, other sections saying said period and other things, I say that the said period is on the period in which the computer output was produced. See, for example, you are taking, let us say, a bank statement for 5 years. It doesn't mean that for 5 years the computer is working properly. It is at the time you are logged into the bank, you are seeing the statement for 5 years. Next click, you get a printout. That is the computer output producing time. During that time, my computer was working properly. It is my computer, so I know that there is no virus or anything like that. This is the essence of section 63 even today. The problem is this original, this thing, because, and one more this thing, 63.3, you please go. I will finish it in another 2-3 minutes, okay. Then we can switch our mind to data protection. No, 63.3. 3, you please go.
எலக்ட்ரானிக் டாக்குமெண்ட் மைனர் மாதிரி எடுத்துக்கணும் எந்த டாக்குமெண்ட் டிஜிட்டல் டாக்குமெண்ட் ப்ராடா அது ப்ராடா இப்போ எலக்ட்ரானிக் இது ரெண்டு ஒன்று தான் நீங்கள் சொன்ன கரெக்டாக.
Yeah. See, now in the section 63.3, one of the things which they have added from the section 65B is that the computer means, okay, computer means and includes one or more computer in standalone form or network, etc. they have given. They have added item E here, even if it is rendered through an intermediary. Please look at section 63, subsection 3, where over any period the function of creating, storing or processing information for the purpose of any activity regularly carried over during that period was regularly performed by means of one or more computers. This is to take it to account this cloud computing and other things, okay. Now, either it can be in a standalone mode, it can be in a computer system which is a combination of hardware, software, it can be a computer network, cloud also is included there, on a computer resource enabling information creation, etc. and through intermediary. I have an issue on this intermediary because the word intermediary means it is a third party. Intermediary, again, definition you have to go back to ITA 2000. This act also says where there is no definition here, you have to refer to ITA 2000. Now, intermediary is a third party. Okay, so from my computer, for example, Shastri was talking about photographic metadata. Now, I want to collect the metadata. Now, I can have a software in my computer and take this metadata, then it is my own tool. But suppose there is a web service. I send the photograph there and they will take the metadata and send it back to me. Then they are acting as my intermediary. Now, if you are adding the intermediary activity as part of the certifier's activity of computer output, then there is an issue there. I am actually standing in confirmation of the intermediary's integrity. Suppose he changes the evidence, I am responsible, no? So, therefore, I see that something needs to be done for that. As far as the intermediary is concerned, I call it as an assurance certificate, okay. Now, fine. So, if you look at these things, now we come to the certificate part. Having these two certificates essentially means that the certifier is asking the person whose device was observed to confirm that he had given that. Okay, that's one. That is an advantage, okay. Now, as far as hash value is concerned, why hash value is important is, we are talking of the electronic evidence, which means that it is the hash value of the file. Say, hash value of the container is a different thing. you can take it as additional information. So, for example, you can say the murder weapon was in a red trunk or something like that. Red trunk was inside, give that, and that red trunk also you can produce it as evidence. Likewise, you can have the hash value for the entire document, but if you calculate the hard disk hash value and use it as evidence, there will be a lot of unrelated documents which will become part of the evidence. Say it contains 500 GB data, what you require is only 10 KB data. So that is one single file. So you have to actually capture that one file, calculate the hash value of that file and use it as an evidence. Computer output. Say, before taking the computer output, whatever you are taking the computer output, you first calculate the hash value for a particular file, which is the object of evidence. You don't have to do it for the entire this thing. Then the possibility of the hash value getting changed and other things will be less. Per file, you can calculate the hash value for the file. Freely available. It is freely available. Free software is available. You can just pick that. So when you give a written certificate, we say that I examined an electronic file of hash value so and so. But if you are talking of an electronic file, you cannot talk of a printout hash value. Hash value cannot be calculated on the printout. So this electronic file has to be an attachment in the electronic form of Section 63 certificate. See, Section 63 certificate computer output can be given either in an electronic form or a paper form. Okay. So only if it is in an electronic form, it is relevant to attach the file with a hash value. So which means that if hash value is a mandatory thing now, it appears that every Section 63 certificate has to be given in electronic form only. It will be only like a covering letter. You can give that, but under this criteria, hash value cannot be calculated on a paper document. So okay, but you have to have a copy of that. No, see, Section 63 certificate should have a reference to the electronic document. So it is attached to that. Is not necessary. Why do you want to bring unnecessary things there? It is like you go to a house and you are doing a search. You don't collect everything which is there. You select what is required for your crime and then collect that. You will say that, okay, I saw so many things, I saw 100 photographs, I picked up this photograph which is of his friend or something like that. No. So let the defense argue why you did not take the other things. Okay, that is different. So if you do this one, some of these problems which we are talking of will try to get sorted out, is what I am trying to say. If you overdo that and say that I will have the whole computer, hard disk and then everything, then you are only multiplying your problems, because corruption of hard disk can take place. Say when you say hash value changes, it is not always because it is tampered. See, when you hold the hard disk for about 3 years, 4 years, the data may get corrupted because of the magnetic nature surrounding or something like that. Then if you calculate the hash value, it will look different. So there will be bad sectors and other things. Therefore, I feel that you focus on what is the electronic evidence, one file, and then look at calculating the hash value of that. In your procedure description, there you make a statement that this file was available in so and so's computer, in C drive, under a particular folio, etc., etc. All that you give it as a description. And say that we captured this particular file which was named so and so. Okay, that is the ultimate identity of that. And I normally take the screenshots of that, like from the desktop home page. Whatever I click, I go to the next page, I take another screenshot. So folder details, so everything we'll take it as a screenshot, so that you can know that, okay, this is what I'm saying in my report, that I went to the desktop, I opened the particular folder, within the folder there was a subfolder, when I opened that a list came. All that I capture as a screenshot just to substantiate the process. But ultimately the evidence is only that one document. But I, to be on the safer side, capture the documents of the entire process. Like in mobile, sometimes in another mobile we take a photograph. These are all actually just to substantiate the, you can say the value of what we have done. So section 63, if you try to read meaning into it, then you will have to find some way of doing that. And when you transfer it from one company to another company, there was one case in Madhya Pradesh, okay, of what was called contemporaneous certification. That is, when you transfer data from one computer to another computer, there has to be a section 65B certificate for each transfer. Okay, this was actually High Court of Madhya Pradesh, Sharadendu Tiwari and Arjun Singh. Okay, I had it in this printed book. Of course, this has been now revised earlier for section 65B. Now I have to rewrite it now. Okay, I did it for the e-book format. But this case was there. That court held that whenever an electronic document is shifted from one container to another container, that is one computer to another computer, that has to be substantiated by what we call as a contemporaneous section 65B certificate. So that the person will say that this was the hash value, I transferred that into this computer, this is the hash value. Okay, so he is responsible for whatever happens in between. So because, for example, in all these video pictures, the cameraman takes it. He is not even a police person, perhaps, let us say a marriage photographer or somebody, you will take him. He captures it first on his camera, inside the camera. Then he transfers it into his USB drive, and then he passes it on to us. There are already 3 transfers which happens here. Okay, but in this they are trying to help the police by saying in some of those cases why they have used this, that also is original, this also is original, is only to avoid this contemporaneous statement, certification. But I think it is not correct, because you cannot have too many originals, is it not? So this says that multiple copies can be called originals. Of course, it happens in the case of books. Actually, in the case of books, we say that multiple copies all can be original, printed material. So they are bringing in that here. That is one point which I want you to note. Second point is this volatile document. I am trying to say that in ITA 2000 there is a problem. Because only if the document is available for subsequent reference, that document is recognized under section 4 of ITA 2000. RAM data is not expected to be available for subsequent reference. So it may not be considered as a legally recognized electronic document at all unless you save it. When you save it, it becomes a stored document. Okay, so these are some of the issues. Right? Thank you.
Thank you very much, Naavi sir, for your excellent presentation.